The information provided in this podcast is for general information purposes only and does not constitute legal advice. Although Will Charlesworth is a qualified lawyer, the content of this discussion is intended to provide general insights into legal topics and should not be relied upon as specific legal advice applicable to your situation. It is also Will's personal opinions. No solicitor-client relationship is established by your listening to or interacting with this podcast.
You know, there's some really, really difficult issues where there is no clear answer, even within a single jurisdiction within the UK. And then when you internationalise the questions, you get a range of unclear answers. And it does make it very difficult for businesses to determine the right course of action.
You're listening to WithAI FM.
Hello, and welcome to the Law with AI podcast. I'm your host, Will Charlesworth. I'm a solicitor specialising in intellectual property and reputation management. I'm also a member of the all-party parliamentary group on artificial intelligence. This podcast is about breaking down and understanding how artificial intelligence is challenging the world of law, policy, and ethics. Every couple of weeks, I'll be looking at important topics such as how AI is impacting on established areas of practice, how it's challenging the law itself on issues such as privacy and intellectual property rights, how it's raising new ethical concerns, and how it's ultimately reshaping the regulatory landscape. To help me in this task, I'll be having some candid and engaging conversations with some fascinating guests, including fellow lawyers, technologists, and policymakers, to gain a real insight into what it means not just for the legal profession, but the commercial landscape and society as a whole. As always, this podcast is for general information purposes only and does not constitute legal advice from myself or any of my guests. It's also the personal opinions of myself and my guests. So, whether you're a lawyer or just someone curious about how AI and the law mix, you're in the right place. So let's jump in to keep you informed, updated, and ahead of the game. Today, I have the pleasure of being joined by Alasdair Taylor. Alasdair is a solicitor specialising in information technology, especially software, data, and AI, and he's also a partner at Keystone Law. He helps his clients to navigate the increasingly complex nexus between law, business, and technology. Before moving to Keystone, he ran his own law firm. He's also, as if how you have time for all of this, he's also the founder of Docular, a software as a service business built upon the idea that software can make legal documents extremely modular and providing automated legal documents to other lawyers and also to tech businesses. So thank you very much for coming onto the podcast. Alasdair, how are you?
Yeah, thank you for having me, Will. I'm very well indeed.
Excellent, good. With such an impressive and varied background, I mean, you bring a wealth of expertise and also some extremely interesting ideas into this area. So I'm very keen to jump in. I have so many questions I want to ask you, and this is such an interesting area. So I'm going to start off with something quite simple, but it's often one of the first questions that people have when I speak to them. So how did you become interested in AI?
Okay, well, it's really, I think, just an aspect of a long-standing interest in software. When I was, 9 or 10 years old, my mother surprised me with a ZX Spectrum 48K, and I was sort of hooked immediately. I spent, many happy hours as a child writing, text adventures and quizzes and fairly simple programs. But then over time, I think that machine eventually broke. There was only one way to fix it, which was to throw it out of a second floor window, and it would sort of come back to life again, and then work for another few months. But eventually, I think all of that throwing out the window did for it. And so I guess I then spent a fairly long period after my Spectrum days without a computer in the house. I think maybe if I'd had a computer all that time, I would have become a software engineer rather than a lawyer. And indeed, I went on after studying law. I had set up the Docular business, and for a period, then I dialed back my practice and actually went to university to study computer science.
Oh, wow.
I dropped out, having discovered that while some of the courses were very interesting, particularly the programming courses, there was quite a lot of, I suppose, material that wasn't really relevant to me as a working lawyer.
Mm-hmm.
And all of these experiences with software, though, led me to have a kind of view that it's one of the few areas of kind of human endeavor where there's a real sort of magic, where you can do amazing, surprising things. I mean, my daughter would say it's perhaps just an aspect of human laziness wanting to automate boring tasks. But for me, the moment when you've written a piece of software and when it does more or less what you were hoping it to do when it does it the first time, that's really inspiring. Then I think it would have been in about 2016, 2017, there were some important books came out about AI. There was Nick Bostrom's book, Superintelligence, I think another book, Life 3.0 by Max Tegmark. And, having I read these books, became kind of, I guess, really fascinated by how AI was going to affect the world in general and legal practice in particular. At that time, there weren't really systems that someone with my levels of technical expertise could implement into a legal business. But for personal reasons, I've spent a couple of years not focused on, watching technological development. So I kind of came back to more or less full-time working at the start of this year, and discovered that obviously AI has exploded in the meantime, and it's all anyone seems to talk about. So I've spent a lot of this year, I suppose, catching up, learning about AI systems, and obviously advising my clients on how the law affects their plans, and in some cases their products that they've developed without consulting a lawyer.
It is so often the way that that innovation drives people forward, and of course there is always a good time to speak to a lawyer, and lawyers would always say that should be very much at the outset, but that's quite often at the very early stage. And if clients are developing their MVP, if they're developing their prototype and working product, it's can be a bit difficult to speak to lawyers at that stage.
Yes.
And how do you use AI in your general practice at the moment?
Yeah, so I mean, I use AI. I tend not to use it very much for my kind of core legal tasks. So I find at least the AI systems I've used, which I won't name right now for this purpose, for legal research, are not sufficiently accurate. They make things up all the time. The hallucinations are they can be subtle. So even if you know the subject, you can read a piece produced by an AI, and if you're not careful, you can think it's right, but then you realize, oh well, actually it's this piece of text isn't quite right, and it's missed out this thing, and it's just I haven't found it accurate enough for legal research, with the exception that I will sometimes use AI tools, if I don't really know where to start in a topic, just to get a list of things to research by other means. In relation to legal drafting, I think the tools are a little bit better, but equally there, we lawyers tend to have our own way of doing things. And what I haven't had time yet to do is to train an AI on my own drafting, which is what what I really want is an AI that will produce will produce contracts, legal documents in the way I would. And that needs training on my work.
Yeah.
So I found, I would say it in terms of the kind of technical legal tools, they're fun to play with. I've used much more of my use of AI has been, outside my work. So for example, I like making websites, and one of the eternal issues I have with websites is that I am a terrible artist, and producing decent illustrations for a website is always a pain. So I found, I've had a lot of fun using particularly Stable Diffusion to produce customized images, which can then be used on websites. I think anyone looking at these things can probably work out where they came from, but it's an enjoyable process creating them anyway. And I would also say for general searching, I do use Perplexity quite a lot. It often gets better, it's often a better search engine than Google these days, albeit I seem to have a habit of typing Google into the address bar if I'm not thinking and deliberately trying to use something else.
It's interesting how other AI tools are challenging and taking over from Google. I do read more and more articles now that the end of Google as we know it is nigh, and particularly as the next generation is seamlessly using AI and not having to think about integrating it, but they are just picking it up and they're using it. I can see how it potentially takes over from and just advances. I suppose it's just the next stage, isn't it?
Yes, and I certainly think if that does happen, Google, Google's the process Google has followed of extracting more and more value for itself out of the internet and the search results, means that I don't think many people are going to be sorry about about that. So I think there's a sense though that when we, all of the things I'm talking about here are generative AI systems, and generative AI has obviously been the most in the headlines over the last few years. But actually, in terms of our day-to-day use of AI, it's very often less obvious. AI systems that are, showing us what we see on the internet or analyzing how we behave, or indeed helping determine whether we have a medical condition where actually maybe AI will have more impact over the short medium term.
Yeah. Yes, it's interesting. For all of the sometimes the articles that come out, there can be a preference for the end of the world is nigh and we will all be destroyed by the machines. There are also an equal number of articles which come out which are talking about particularly medical applications, and I know that speaking with some doctors, they're already working with AI companies within various hospitals to train models, and the results are quite incredible in terms of it's just data processing and analysis. And of course, there are a lot of things that AI has to learn to do, and that will take varying amounts of time. As you said before, it can be it's quite difficult. You can't rely on it certainly for important things such as medicine or legal advice. But probably at this stage, the most common thing I hear is that it's a good starting point. It's a good thing that launches you into a topic or a subject, or it expands what you're thinking about, and you can delve into it and you can do your own research and you can create your own products or your own content from there. In terms of obviously you're a technology commercial lawyer. What are you finding in terms of your clients? In terms of how are they? Is it something conscious that you're aware of, that they're approaching AI and they're embracing it and they're asking for specific advice around it, or is it something that's still not talked about as much? What's it like at the coalface?
So I think there's a little bit of a split. So those clients that have always been doing AI, who have AI that predated sort of 2020, November 2022, have tended, to not see it so much as a special legal issue. So I have one client, for example, a software developer who part of their offering has been AI systems for a long time, and other, again, SaaS companies where they have implemented, I'm thinking of facial recognition system, which they implemented without really taking advice in advance. In that case, rather unfortunately. Then, we have other clients that have, sort of or projects which have really come off the back of the explosion in interest in AI over the last couple of years, and they tend to be more, actually more thoughtful about the legal issues, given that all the noise about legal cases associated with the new AI services. I mean, there's a number of different sorts of issues that I'm seeing. I mean, some of them are, there's obviously the data privacy issues, which, and there's kind of two aspects to those. There's or three aspects, I would even say. There's the using, businesses and individuals providing their personal data, which then is potentially, first of all, provided to the service providers for some use, and potentially even incorporated in some sense into models, for in ways that cannot be predicted or necessarily understood very well for extraction
the black
later.
box nature of AI, being we're not quite sure how it's processing or how the algorithms are dealing with that, breaking down that data.
Yeah. A second issue, which is, I think, a little bit less visible sometimes, but which has come up in my work, has been the use of AI to analyze data sets and produce personal data, potentially sensitive or special category personal data, where there was none before. And a question, a live question here is the extent to which, if you have such a data set and you have, in some sense, access to algorithms that may be able to extract or create personal data from that data set, do you have personal data, in your hands at that point before you've even done that extraction work? And this, it seems to me that this issue, it came up in my work in the context of an Internet of Things business, which generated, which collected data about people's behavior, and there's nothing that a human could do looking at that data really necessarily to derive any special category data, but with an AI it is absolutely possible. So it puts the client, which is a relatively small business, in a tricky position. Do they treat all of this data as special category data and have to deal with, for example, establishing a legal basis of processing, probably explicit consent for any use of that data?
Yes.
How can they do that in the case of an AI model, given that consent, if you're using explicit consent as your Article 9 basis, consent should be your Article 6 basis, and all that needs to be withdrawable? I mean, do you retrain your model when someone withdraws a consent if it's used in training? So, yeah, it's really... there's some really, really difficult issues where there is no clear answer, even within a single jurisdiction within the UK. And then when you internationalize the questions, you get a range of unclear answers, and it does make it very difficult for businesses to determine the right course of action. I guess one thing I would add to that, though, is having become used to dealing with the GDPR, and as you will be well aware, Will, there was periods when it was impossible to be sure if international transfers of certain kinds of data were lawful or not, or it appeared that it wasn't possible to make some fairly standard kinds of international transfer in a lawful way. I think technology businesses have become used a little bit to treating the law as perhaps a relatively flexible set of rules, rather than this kind of traditional idea of an absolute set of clear guidelines that we all need to comply with.
We see our lawyer at the outset. We get the stamp of approval and certification, and then we march on. Yeah, no, that's a really interesting point. And I think the clients are definitely best served when they keep that dialogue open with you as well. But obviously, as a lawyer, that puts an emphasis on you making sure your clients are aware of updates, because it's an ever shifting landscape, isn't it? I mean, particularly, not just the UK, and then Europe as well, and the US, and any other jurisdiction that you want to operate in.
Yeah, and I wonder, the US, are we going to see the same thing as we've seen with data privacy, whereby it's the states that become the primary actors in the absence of federal action?
Yes, yeah, which adds another very interesting dimension to it.
Yeah. Now, I mean, there was one particular project that I mentioned before that my client in this case, which is the Serpentine Galleries, has very kindly said that they're happy for me to talk about this project.
Oh, fantastic.
And this was one of the most interesting pieces of work I've done this year. So this related to a project called The Call, by the artists Holly Herndon and Matt Dryhurst, which is, I think, still currently being exhibited at Serpentine Galleries. And this project was conceived with the idea of giving agency to contributors to an AI model. So I suppose the primary output of the project has been a choral AI that through you can prompt to produce choral music.
Oh, wow.
So if you go down to the Serpentine Galleries, you can stand in front of a microphone and make noise, and it will sing back at you. And this model, or rather these, I think there's more than that. There's a number of different models, but these were trained using recordings of compositions created by Holly and Matt, which were then sung by choirs around the UK. And what the artist wanted was to give the choristers and the choirs some kind of control, not a control, but power, interest, agency in what happens to those recordings downstream. So the AWO, another law firm, were assisting with the data protection aspects of this, and I was assisting with the intellectual property rights, and mainly focused around performers' rights. So we initially gave some advice on how the intellectual property rights landscape applies to the project generally, which was sort of that, needless to say, there was a lot of question marks and relatively few firm conclusions.
Yes.
And then we produced licensing and contractual documentation to give effect to this project goal. So it's the first time I've been involved in a project which involved contracts and licenses, which are in some sense artwork. So I'm rather pleased by that.
Sounds like a very interesting project.
Yes, definitely. And it's, I think, the documentation from that is going to be all, if it's not already, it's all going to be publicly available for use.
Oh, fantastic.
In other projects. And what's, one aspect of something like that, obviously, is that we needed to take a very, a clear style and try and get all this complexity and mess of the interaction of intellectual property rights and AI training processes and AI outputs and all that sort of thing, and turn that into documents that were really clear, that could be read and understood and hopefully agreed to by non-lawyers without any difficulty.
That is one of the that's one of the main challenges, is turning something which, as a lawyer, you're probably quite comfortable with, because you've been, I suppose, living and breathing that document as well as you've drafted it. But then, making that easily understandable to a lay person, so you have their informed consent to it, which is a very interesting challenge, but very rewarding once you've completed that task.
Yes, yeah. I mean, what another aspect of that project was the idea of a data trustee. So there's been a lot of academic writings about this idea, and about how, because it's on having a lot of contribute. When you contribute a small amount of data or IP to a project, it's not really feasible for you individually to exercise rights in relation to downstream users. But if you have some kind of fiduciary or trustee who can exercise those rights on your behalf, then that's one way, at least, of achieving this kind of agency goal. So so it had this data. The data trustee then became really, that it was structured very much as a license to the data trustee, allowing the data trustee to sub-license and subject to good faith and consultation and notification obligations. So a very interesting project.
My goodness, gosh, and that's something that's nice and tangible, because you don't always get that as a lawyer. You can work on some projects as being a part of a much bigger puzzle that you never actually see the outcome of, or even if you do, it's something that's very discreet and it's not something that's that physically you can see. But at least with the Serpentine project, that's really exciting. You can go down there and you can fully interact with it as well.
Yes, yeah, and it definitely also encouraged me. I need to get on with training my own drafting model that's going to write my contracts for me in the style I like.
Well, perhaps that's the next part of that part of your project then, is to work on that. I mean, from what you've said, as you say, advising in the area of AI or even any kind of technology law, it requires a lot of creative thinking sometimes as well, in adapting the law to an ever-evolving and rapidly changing, I mean, particularly with AI, rapidly changing technology, having to find a fix effectively as to what possibly works best, subject to annoying litigators like myself going to court and having a ruling in a slightly different way, or perhaps providing clarity, which is what I like to think it does. In terms of so for the non-lawyers, so for the technology companies, and just generally businesses that are looking to adapt and integrate AI more into their operations, because I suspect that everybody in some ways has already integrated it to a certain extent, whether they're aware of that or not. But what are the types of I suppose risks, or the key things that you'd be saying that people should at least be aware of anyway?
Okay, yeah. I mean, I think from a customer perspective, you use the term black box, and that from a customer perspective, that can apply to any, SaaS or cloud service. You don't really, you don't have oversight of what's going into it, and that issue is especially acute with an AI-based system, because even the developer deployer might not be able to say or predict what the outputs of a system might be. So it helps, though, having said that, to understand as much as possible about the system in question. How was it trained? How's it been tested? And how's it been validated? What levels of accuracy and inaccuracy can be expected from output, from the outputs of that system. How is the system going to be, is that system static, or is it going to be changing through the the life cycle? And if it's changing, how is that going to affect your understanding of that system? There's obviously the vendor side of this as well, where a vendor needs to understand how the system is going to be used, and just as a customer will never have perfect knowledge of what's gone into the system, a vendor will never have perfect knowledge of how it's going to be used. But I think if the vendor and the customer can each sort of understand each other, largely, then that's always going to make coming to a deal a lot easier, because they can then identify what the actual real risks are, and determine, agree who is going to be responsible for mitigating those, or where they can't be mitigated, insuring against them, or ultimately, accepting liability.
So the key is to ask lots of questions and to actually get as much as you can, as much information as you can about the system, and almost plan that out or map that out. And obviously you can do that with a client if they want some assistance on that. You can sit down and kind of plot those, if it's data flows through the system, inputs and outputs, and if they're developing a new technology, as you say, take apart as to exactly how much you can say how it works, and how it actually processes, I suppose, inputs and outputs, essentially, to take everything down to inputs and outputs. But there you go.
Yeah, and I mean, I think also, in the in the phase of purchasing new products, it's important that the customer has an understanding of the possibilities. What can be done in terms of data use, and what can't be done. Is the application they're looking for one where they can keep their data entirely siloed, or is it something where the application provider, to some degree, is going to want to use their data, or going to require the use of their data for further training? Clearly, if you're buying a system online without a kind of due diligence and negotiation process, you should assume that your data is perhaps going to be used in ways that you wouldn't necessarily like.
No, and obviously the obligation on a business to ensure that data is dealt with in accordance with the obligations, the regulatory obligations on them, is extremely important, which is perhaps slightly different to how outside of a commercial business context, people have to a certain extent gotten used to, through social media, I suppose, surrendering their personal data, and that's a whole other conversation around that. But if a new piece of technology, say a generative AI, a large language model, is presented to you and it makes things more efficient and easier to use, then I think, from speaking with people outside of the legal sphere, is that they generally tend to be quite happy to not have any thought as to what they're inputting into that system. And as long as what they get out is remotely useful, then they're quite happy. And most of the time you're not paying for it with money. Obviously, you're paying for it with training their system to become more accurate, and so I suppose that's kind of a trade-off as well. It's perhaps getting the client, the business, to think about it in terms of their regulatory obligations, and to ensure that that's compliant, outside of any, I suppose,
Yeah.
appealing to consumers as well, to make that as frictionless as possible.
Yeah, I mean, it sometimes seems to be assumed, though, that to train a model with personal data would need, you need in some sense to get consent. And of course, that's not necessarily the case. It could be that you could train on the basis of legitimate interests, or perhaps performance of a contract in some scenarios. It's a question that's going to arise, though, there always is, well, if you're training on a legitimate interest basis, what does your legitimate interest assessment look like? How can you balance, the potential for data that going into a system that might, through some, even if you've put in place guardrails, that might somehow still be gotten out of that system against, in contexts that you don't necessarily know what they are, against the the rights and freedoms of data subjects. I guess it's kind of difficult for anyone to say, well, that's you're clearly always going to pass that balancing test. So important, therefore, in any system where personal data is being trained, to have a clear allocation of responsibility and liability and indemnity provisions relating to I guess regulatory actions, and indeed private actions over the misuse of data in that context. My suspicion is, though, that because personal data coming out of models is going to come out in, I assume, generally in dribs and drabs rather than wholesale, it may be that providers are taking a view that the real risks there are not as significant as you might think.
No. And in terms of something I've been asking people recently is there's a lot of things written about AI, of course, and being in the legal sphere, having experience in dealing with and advising clients about the law around this. Is there anything you think that is perhaps not being addressed or not being spoken about enough in terms of AI, which you are very well aware of, and you're kind of maybe quite surprised that it's not being discussed more, or you just think generally this is a topic which is really very relevant and it needs to be considered further?
Yeah, well, as you will be aware, Will, if you look at the case law on the various AI case law trackers concerning AI, it is predominantly content providers suing AI companies in relation to training materials. And there's also there's some claims relating to infringement by AI outputs. And there is a huge amount of discussion around, IP and training issues, and quite a lot of discussion also around outputs. But I think my personal hobby horse at the moment is actually, the application of intellectual property law to the models themselves, and how should they fit into the intellectual property framework. I mean, currently, they, as with other aspects of artificial intelligence systems, the kind of core categories of intellectual property law generally, and copyright law in particular, don't map very well onto what's going on when someone trains or uses an AI model. And the AI model itself is not, as a matter of English law, it's not very clear that it's protected by anything. There's an argument that copyright might protect an AI model, but in that case, you need an author, and you need some originality, and you need that model to be an original literary work. And yeah, it may well not be, depending what the courts say. An alternative approach is to treat models as databases, but they don't, because they're not because of the way they're organized, although they are a data set of sorts, they don't clearly fall within the definition of database right either. My preference, I think, I think over the past sort of, 40 years with the information technology revolution, we've seen copyright, evolve, and it's, been extremely successful in taking account of new technologies. My intuition is that it will be less successful with AI because some of the fundamentals are so different, because concepts such as, originality, what does it mean to talk about a model being original? What does it mean to say that you're training a model? I mean, that's not copying itself, the transfer from the training material into the model file is not copying itself. Who's the author in these cases? All of these kind of core concepts just don't really fit very well. So my feeling is that it would be really nice if we had some kind of new model right, something like database right, that wasn't as so not as powerful as copyright, but that gave some sort of protection for the economic investment involved in creating a model. Of course, for that to be successful, we need some international cooperation, which, whilst there are obviously people working on these things, the international environment at the moment isn't one where new treaties on intellectual property rights and so on are seem to be imminent.
No. So definitely a case of watch this space, but perhaps let's not hold our breath too much.
Yeah, I mean, given the preponderance of case law in the US, it may be that the world, or at least Europe in this case, ends up following the US courts. There's been a bit of an expectation that it might be the same as with, the GDPR, and the US sort of follows begrudgingly behind the EU. I wonder if it'll be the other way around this time, though.
Yes, quite possibly. Yes, and thank you very much for that. That's a very interesting point to probably kind of finish on. If people want to contact you, how do they go about it? And also, let us know the details about Docula as well.
Okay, well, if anyone would like to speak to me about any software, AI, data, legal matters, they are very welcome to contact me. My contact details are all on the Keystone Law website, and also on docula.net. If you fill in the form there, that will come through to me. So yeah, I'm very happy to talk about anything to do with technology and law.
That's fantastic. And thank you very much. I extend my deepest gratitude for you coming on and talking about this and sharing your expertise, and also some practical real life examples of how we can adapt and to use the law to advise on real life, and very interesting, very interactive AI projects as well. So thanks very much, Alasdair, for taking the time to join me on the podcast. I really appreciate it.
Thanks very much for having me, Will.
Thank you. And thank you everybody for tuning in as well. And don't forget to like and subscribe if you haven't already to the podcast. And I will catch you in the next episode.